Your Honor, with and on behalf of Ms. Lavaz, we're requesting jointly a 3-week adjournment of the PCC because discovery is still being provided and investigation is still ongoing.
Right out of the gate, this is classic courtroom strategy. When both sides agree to an adjournment, it usually means one thing: the case isn't ready. And there's more evidence coming. The real question is, what are they still uncovering?
That's negotiation.
Okay. 21st?
Yes,
All right, May 21st, 2026, 9 a.m. Bond will continue.
very good. Thank you, Judge.
Court calls case People versus
Ricarte,
Carthy.
John Shea, on behalf of Ricarte, who I believe is somewhere in Boomland. There he is. Isidro,
Hi,
can you
I'm here, yeah.
name for the record?
Isidro Ricardo.
Thank you, Isidro. Your Honor, Mr. Kennedy advises me that I'm getting discovery.
Notice the pattern? Another delay tied to discovery. In legal terms, discovery is everything. It's the evidence, the reports, the receipts. No lawyer wants to move forward blind. Would you go to trial without seeing the full case against you?
Supplemental discovery today. I haven't received it yet, but I have no reason to. I have every confidence that I'm going to get it sometime today, but I'm going to need some time to. If I could ask for a 2-week adjournment of the piece.
One at the 14th or the same day as the other one.
We could do it on the same day as the other. That would be great.
Court will adjourn this matter to May 21st, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Isidro, I'll give you a call later. Thank you.
Court calls the case People versus Tjan West.
Thank you.
Good afternoon, Your Honor. Raymond Cook with People.
Yes, and good afternoon, Your Honor. Robert McCoy on behalf of Mr. Tjan West, who is coaching. Oh, and then I have my law clerk. I wanted to introduce her, Mira Osborne. She's about to graduate from Detroit Mercy Law School.
From where?
Detroit Mercy.
Sure. Oh, sorry. All right. Your name, sir?
Tjan West.
Actually, I have nothing against her. See, I don't know why I said that. Because I tagged. All right. What are we doing?
Your Honor, we're going to be asking for an adjournment for some additional discussion, negotiation. I would also ask.
All right. And how much time would you need for that?
3 weeks.
About 20?
No, I think because I did talk to the officer, I think maybe a couple months.
A month?
Okay, now this is where things get awkward. The judge is basically side-eyeing the timeline like a month. Seriously? You can feel the tension here. Even in court, negotiation is a game of patience and persuasion.
Well, there's something
A
else.
month? This is a new law student. You're going to future lawyer. You're teaching that. A month?
We're trying to get some other issues resolved.
There's some county investigations going on, but I don't know the time frame.
Why were you helping? You want the 28th then? May 20.
May 28th. Yes.
Okay, May 28th, 2000.
Oh, I do. Wait, I have something at 10 o'clock on May 28th.
Will you be done by, say, 12:30?
It's a family law case. So it could be, then I
Is
have,
that a no?
that's,
Hang on.
you know what?
You know what? No, here. You want to do June 4th?
Let's see, because I'm looking at this family law stuff. This,
You're killing me, McCoy.
if we can,
Which day do you want?
you know what? Let's see, maybe the 28th, if it's like a 12:30 or 1 o'clock,
We'll figure it out.
we'll figure it out.
All right.
Not, it'll be Mr. Taylor coming over here.
Probable cause will be adjourned May 28th, 2026, 9 a.m. As to bond.
I would be asking if the town of the court order a GPS.
And here we go. This is a big moment. The prosecution is asking for a GPS tether. That's not just paperwork, that's real-world monitoring. Translation. The court is starting to worry about public safety.
Tracking tether. The reason for this request, I spoke with a detective sergeant out of the Beverly Hills Public Safety. he informed me this morning that there's ongoing investigation into a string of larcenies from various automobiles in their county. As well as I received a report indicating that last Saturday, April 25th, the defendant may have been involved in scouting out a house for a potential home. There's no charges that have been brought yet. I'm not asking for the man, but we given this additional investigation, a GPS tracking tether would be in the interest of public safety.
And Your Honor, I did talk with my client about that. He has, there's a mother, he has his expecting baby, a mother, and he was trying to find her. She sent him this address. He went out there to find her. So I talked to the sergeant and told him we were going to submit that information to him. And then he said that they're going to look at it, evaluate it, and let us know what they're going to do about that. So, so for that reason, we would object to the tether because he said he was going out there to find the mother of his child who was expecting a baby.
Are the
They've got-
other things that are being investigated, are they similar to what the allegations are here?
I don't know the full nature of what's out of county. My understanding based off the conversation with the detective sergeant is that there's been a string of larcenies from automobiles where things have been stolen. And that there's a group of individuals that they believe are perpetrating those, and that the defendant is involved with that group. That's the full extent of knowledge I have about that investigation. And I would just note that as it relates to the incident.
2:23 a.m. Looking through windows. And now a story about searching for a baby mama. Be honest, does that sound convincing to you? This is exactly the kind of detail judges zero in on when deciding credibility.
The incident from this past Saturday, the time that the defendant was at this house was at 2:23 in the morning. And at least according to some of the ring camera shows the defendant were looking into the house and there's a chair moved right underneath the windows if someone stepped up to look into the windows for scouting at the house. So I'm concerned about the claim that he's looking for the mother of a potential child. It seems a bit incredulous.
Well, I did talk to Sergeant Brewster on the case, and my client is forwarding those texts to me. He said that he was looking for the mother of his child. She told him
2 o'clock in the morning?
she said, baby, this baby daddy, baby mama drowned. He said she told him, he said that she said she was at an Airbnb and he was looking for her. He's like, where are you? You have my baby. She sends him this random address. He goes out there to find her. And that's not the same as somebody just looking in windows to do stuff. That's different. He's looking for his baby mama and the baby. Well, the baby to be. He knows he knows he's on bond to this court. So, I've encouraged him to find other ways to deal with that relationship.
In some other way, but at this point I am going to.
And there it is, the decision lands. Despite the defense's explanation, the judge isn't taking chances. This is how courts balance freedom vs risk. If there's even a hint of danger, restrictions come first.
Put a tether on him, given out both of those circumstances.
Okay.
Defendant is to report over to the Department of Community Corrections for placement of GPS tracking tether.
Okay. And
Might
then,
as well do it before you leave here.
okay. And then, Your Honor, he does work. He has 2 jobs. He works 7 days a week. So he works at the hair salon and he also does custodial work. So we want to make sure that the tether is able to make, because he has another child, a 2-year-old. So he works and he wants to be able to go to work. What are your hours?
Wednesday through.
Well, I'm not. Want me to lock him down in his house? I'm not asking for that. I don't think
Okay.
we're asking for that. This is just a GPS location tracking. We're just going to know where he is.
Okay, that's fine.
Thank you.
All right.
Yeah.
No.
Yep. You said he would? No, you see. You know at least where you're okay. You know where she is, right? And her name. Hey, oh, here, her. Okay. Court calls the case of the people versus Dana Fletcher.
Attorney Mark McManus on behalf of Dana Fletcher. Speak your name.
Dana Fletcher.
All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor, there has been an amended complaint. I'm not sure if we have to do that first before the plea.
Well, hold on. I thought we did it last time where
It-
there was a, what?
It was filed with us after.
It was filed after the last hearing.
Yes,
All
Your Honor.
right. And so that's the count 3, which is the operating while intoxicated second offense. Counsel, as to the arraignment on that, your client waives formal reading and stand.
He does, Your
Just
Honor.
that.
Thank you. Yes.
All right. And so court will enter a not guilty plea as to that added count 3. But that means, hold on a second.
Count 2 was deleted.
Count 2 was deleted, but count 2 was the operating while intoxicated. I just want to make sure that his bond conditions match a drinking and driving offense, but I think they do.
They do, Your Honor.
All right, very good. All right. So now we have that. The
Now we shift gears completely. This is a plea deal. No trial, no jury, just a direct admission. Why? Because sometimes the evidence is so strong, the smarter move is to negotiate the outcome instead of risking something worse.
the plea form indicates that the defendant will be pleading to count 3, the operating while intoxicated second offense, the 1-year offense, and an added count 4 of use of a controlled substance, that being fentanyl, the 1-year offense. Upon a successful plea to those charges, count 1 would be dismissed. That is the court's full understanding of the agreement. Is that correct, counsel?
It is, Your Honor.
All right, very good. Sir, if you can please raise your right hand to be sworn.
Speak loud.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again, please, sir.
Dana Fletcher.
All right. Sir, it is this court's understanding that you're going to be pleading to 2 misdemeanor charges. The first being the stated count 3 of operating while intoxicated second offense. That's a misdemeanor punishable by up to 5 days to 1 year in jail, up to a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
The other charge, the added count 4 of use of a controlled substance, that's a misdemeanor punishable by up to 1 year, a $2,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. Understand that?
Yes, Your Honor.
Understanding all of that, to the charge of operating while intoxicated second offense, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
If you see a copy, looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rank.
Yes, sir.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
On the date of December 31st, 2023, at the location of US 23 near Nixon Road in Ann Arbor Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes, Your Honor.
And what had you ingested, sir?
Fentanyl.
That single word changes everything. Fentanyl. In today's courts, that's taken extremely seriously. Combine that with driving. The legal consequences stack up fast.
All right. And did you know that what you were ingesting was fentanyl?
Yes, Your Honor.
All right. Were you stopped by the police at some point?
Yes, Your Honor.
All right. Why'd they stop you?
Speed?
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood draw?
Yes. Yes.
All right. Did the results of that blood draw show the presence of fentanyl and or its derivative in your system?
Yes, Your Honor.
Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Had you previously been convicted on or about January 20th, 2021 in Bowling Green, Ohio of the offense of operating under the influence of alcohol or drugs?
Yes, Your Honor.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
You are satisfied.
We are satisfied, Your Honor.
And just like that, it's done. Plea accepted, sentencing scheduled. No dramatic trial, no last-minute twist, but make no mistake. The consequences are still coming in.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Count 1 is dismissed. Pre-sentence investigation and report and screening and assessment is hereby ordered at 14A2 probation. Sentencing in this matter will be May 26, 2026, 10 a.m. before Judge Barr.
Thank you very much, Your Honor.
Thank you. Bond with its conditions will continue. Thank you.
Thank you very much, Your Honor.
Court calls case of the people versus Desmond Hodge.
Good afternoon, Your Honor. Raymond Cook.
Good afternoon, Your Honor. James Feifelsky appearing with and on behalf of Hodge, who is approaching. You state your name, please.
Desmond Hodge. Oh,
Judge, I believe all discovery is in. To the best of my knowledge, we'd ask the court to set this for a preliminary exam.
And Your Honor, I sent 2 emails yesterday. One of them, I initially thought there was no additional discovery. The agency got back to me and said, actually, it was under a different case number. So there may be additional video that has not been marked yet. I only just got that video. I don't know if it's for this case or if it was for a different case because I haven't had the opportunity to watch it yet. It's a couple hours long, but there may be more discovery that's still needs to get sent.
If the court
4 hours of video evidence? That's massive. Cases can flip completely depending on what's inside footage like that. The question is, what haven't we seen yet?
can set this out, we're comfortable moving forward with what we have, understanding if there is additional discovery, it'd probably show up within the next week or so.
Hopefully week again, there's about 4 hours and they do start a trial Monday next week. So
There's 4 you think there's 4 hours of video?
that's why I saw on the timestamps at evans.com, there's numerous videos. I added up quickly about 4 hours.
All right, I'm gonna adjourn the probable cause. Let's get the discovery and if there's 4 hours of video, gonna at least have to look at it. I'm gonna adjourn it out to May 14, 2026, 9 a.m.
Your Honor, I am seeing that I believe my client has a review hearing. Well, if it's later in the morning or 12:30, it'll work. He's got a review on a case that arose from the same date and time in 14B, for which he's on probation. That's at 10 o'clock, so I think we'll be okay.
For this gentleman?
Yes, Mr. Hodge.
Okay, so theoretically, unless you had somebody in custody, you're gonna be in this block, so he shouldn't be
That will
14B that long and be able to get over.
that'll work out perfectly. Okay, thank you.
All right, thank you, sir.
Well,
14. Court calls the case People versus Barrett Kahneman.
And people, Your Honor.
Good afternoon, Your Honor. Allison Cass is appearing on behalf of Mr. Shannon, who is appearing by Zoom.
Mr. Shanneman, can you state your name, please, sir?
Barrett Shanneman.
All right, I have before me a plea form that indicates defendant's going to be pleading to the stated count 2 of domestic violence, a 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. There's also an agreement to sentencing under 7694A. That's the court's full understanding.
That's correct.
Okay. Sir, can you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name again, please.
Barrett Shanneman.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
Understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.